B2 is all other lists, Malas.
No, no. B2 says such other matters in the said list as with the concurrence of the government, the president may order
That's an
specified.
all list, all matters in the list.
Right, right. Of
Yes.
course, it covers. It's a residuary.
Everything, Malas, everything.
Yeah. So you have to take the concurrence of the state.
Yes.
Now, suppose it is not covered by B2 in the sense that there is no concurrence of the state. Right? It's not covered by B1.
Yes.
And you have not taken the concurrence of the state under B2.
Correct.
On such an aspect, the state legislature cannot exercise power because it's not in the state list. One second, Nizam, one second. Nizam, 1 second.
Residuary power of the
1
state.
second.
Yeah.
The state legislature, the state legislature is operating on the state list.
And residuary power, Malas.
Residuary power came in and when? Under what?
Other way around, Malas.
No,
Kashmir, it was there from the beginning.
Where does the residuary power find?
Yes, I'll show that to you, Lord. This is part of the instrument itself.
Instrument of accession.
Yes, it is part of Malas. All orders of the government.
No, but has specifically there's
It's also part of the constitution. Malas. I'll show
I
that.
just wanted to see whether it's part.
Yes, yes, yes. You're always to take it, Malas.
Because otherwise there'll be a peculiar situation.
Yes.
Where neither parliament can exercise power,
I will
nor can the state legislature
I
exercise
take
power.
your lordship's point. I will demonstrate to
Yeah.
your lordships that the residuary power was with the state legislature throughout and with the state government throughout. That was the condition on which, Malas, the accession took place. And I will demonstrate that to your lordship. That's
Mr. Sibal,
that's
slightly
the least of
different.
my problems.
Mr. Sibal, slightly different.
Okay. Yes. Yes.
Which is very different from what is subject matter of 1 and 2,
Yes. Right.
because they do not deal with abrogation of the
Absolutely.
article.
Absolutely.
Right.
Yes, absolutely. Your lordship is right.
And therefore, when we read at that power, which is specifically conferred on the president,
Yes.
then proviso, leave aside for the time being the proviso. Do you agree with that interpretation?
No, I
Or
don't.
for the time being, just leave the proviso.
Well, I can't read the constitution in this fashion. I can't even read an act in that fashion. Let's forget the constitution. How do I leave the proviso when the constitution is staring us in the face?
No. The question
Your lordship
was,
is putting to me.
therefore, clause 3 deals with abrogation of the article itself, which is not the subject matter of 1 and 2.
No, it's subject matter of C. Article 1 shall apply to the state.
No, correct, but it deals with complete abrogation of the article itself.
I agree.
And in that context, you may argue that your argument at the first fold was, it will be only if the conditions of the proviso is satisfied, that clause 3 will apply. Otherwise, if the conditions of the
That's how
proviso
your
are not
lordships have
satisfied,
interpreted-
clause 3 will not
That's
apply.
how your lordships have interpreted proviso since 1950, Malas. That's all that I can say. I can't say more than that.
A proviso may in some cases be an exception. A proviso may in some cases be an elaboration.
There's a
or-
difference, Malas. Yes.
It depends upon the nature of the.
The-
Provisos are sometimes change
That's
colors.
proviso, Malas. Proviso that the
One
recommendation,
rule for a proviso in that sense.
provided that the recommendation of the legislative, of the Constituent Assembly shall be necessary. It's a restriction on the exercise of power. That's right, referred to in clause 2, Malas.
Quick way to interpret clause 3 to say that the power existed and then will vanish once the Constitutional Assembly of the state is no longer exists.
Well, but you kindly read 2, Malas. If the concurrence of the government of the state referred to in para 2, subclause B of 1 of the second proviso to D of that clause be given before the Constituent Assembly for the purpose of framing of the Constitution that's the purpose.
Mr. Sibal, you have contradicted yourself. When you refer to clause C, subclause C is an independent clause and clause D not applicable to clause C,
No,
then
what
the
I'm
second
saying is,
proviso will not apply.
in both cases,
And therefore, only subclause 3 will apply.
Malas, Point is, clause 2 says that
clause 3 will apply.
even for the purposes of those notifications.
Anyway, we'll examine that.
Yes.
We have understood your line of
no,
argument.
No, there is something that's missing, Malas. The proviso says, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. Why are they saying that, Malas? The purpose is given in clause 2. Provided that the recommendations of the Constituent Assembly of the state referred to in clause 2 shall be necessary for the president before the president issues such a notification. It is necessary and before he issues it. How can you say that it's explanatory or that it's an independent clause? It specifies how it is to happen. It has to happen before. That is, the permission has to have before.
You know, the reason why clause 3 refers to the Constituent Assembly of the state referred to in clause 2 is because clause 2 refers to the Constituent Assembly for the purpose of framing the Constitution.
That's correct. That's exactly
right? That's your point. You get that point.
Yeah.
Now, therefore, the recommendation of which Constituent Assembly, this makes it very clear that one and only Constituent Assembly which was formed for the purpose of framing of the state constitution.
Right.
Once the frame of the constitution was done, then that purpose of the Constituent Assembly is not like a permanent body. Like Parliament is a permanent body. The Supreme Court is a permanent body.
No doubt about it.
It's a body which has a specific purpose and then after it becomes functus officio, so to speak.
Right.
Therefore, once the Constituent Assembly had fulfilled its purpose, then the proviso itself has no application.
No, this is the problem, Malaj, with the problem there is when you are applying 3 without the proviso and saying this is a blanket power, then Malaj, the president can do it anytime without any consultation with anybody.
Sibal, one thing which we must
passes an order.
Mr.
I
Sibal,
integrate. That's
one thing which we have to also bear in mind is all these provisions are in Part 21. Part 21 has used 3 expressions: temporary, transitional, and special.
Correct.
Temporary provisions are those which are intended to be in existence for a limited period of time,
That's right.
but without a point of terminus, right? A temporary government servant. That person is temporary for a limited period of time, but whose services are to be terminated. Until you are terminating the services of that person still continues.
Right.
That's that broad concept, of temporary.
Absolutely right.
Transitional means something which necessarily has a terminus.
That's right.
Laws made
earlier.
I'll show you some of the transitional provisions in this part.
Right.
And third is special.
Right.
Now we'll see, for instance, after 370, we'll get some idea from the provisions after 370. Say 371, special provision with respect to Maharashtra and Gujarat. 371A, special provision for Nagaland.
Yes.
Then we get 371B, special provision for Assam.
Correct.
371C, special provision for Manipur.
That's correct.
D, for the state of Andhra Pradesh and Telangana.
Right.
E, establishment of Central University in AP. F is special provision for Sikkim, which came in 75.
Right.
G, Mizoram. H, special provision for Arunachal.
Yeah.
Then I for state of Goa. J for the state of Karnataka.
Right.
Now, after these special provisions end, we come to 372,
Right.
which continuance in force of existing laws.
Yes.
Which then says, shall continue in force until altered or repealed or amended by a competent legislature or by any other, like the penal code.
Right.
It just continued in force until it is altered. Then similarly, now we have 372A, power of the president to adapt laws.
Right.
And it says the president may by order made before the 1st of November 1957 make such adaptations and modifications.
Right.
So this was a transitional provision that the president had to make those adaptations by the 1st of November 1957. So it was a transitional provision. After that, the power lapses. So similarly, 373, was then came the provisions relating to the judges whose services had to be taken over by the Union of India, public service commissions, so on and so forth. And then 392, the power of the president to remove difficulties.
Right.
So therefore, part 21 basically covers special provisions, temporary provisions, and transitional provisions.
Right.
Now, it doesn't use the expression transitional in any head note or marginal note to the articles. But temporary and special are used in the marginal notes to specific articles of Part 21. And 370 specifically uses the expression temporary.
It had to, Malad. It had to.
So, can we then, by saying that the power under clause 3 goes once the Constituent Assembly comes to an end, really convert this into a permanent provision, which it was never intended to be by the
But
Constitution?
that's, your lordships are now putting to me, it was never intended to be. Within 370, when it was put in, it had to be a temporary provision. It had to be, Malad. There was nothing there at that point in time. It had to be, Malad. It could never be a permanent thing.
But why did the Constitution then put it in Part 21?
Because, Malaj, it is a separate, it relates to a particular state where the two sovereigns have come together and made a compact which is incorporated and integrated.
No, Part 21 does not deal only with Kashmir. Doesn't deal only with Jammu and Kashmir. It deals with other states also.
I'm sorry, I didn't get.
Part 21
Yes.
does not deal only with Jammu and Kashmir.
No, of course not. That's why I think it's a separate, independent provision and has to be interpreted on its own terms. You can't incorporate, Malaj, concepts outside of 370 and integrate them into 370 and say, this is how we'll read 370. Yes. 370 is not temporary. 370 is not temporary.
General note expressly says it's temporary.
No, it says temporary provisions with respect to temporary provisions. In other words, this is a provision which is temporary till such time as the Constituent Assembly decides this way or that way. That's the whole purpose, Malaj. Because when the Constitution came into force, there was no such thing as the Constituent Assembly even. How did the Constitution add this here? Because there was an understanding. Otherwise, why would you bring in the term Constituent Assembly in 370? It was not anywhere else. Temporary, supposing, Malad, not that I should say so, because one never knows. Supposing the Constituent Assembly decided not to be with India, then what happens? We would have to do what we did to Junagadh.
You know, there are two types of temporary provisions in Part 21. One type is Article 369. 369 says Parliament had the power to make laws for a period of 5 years.
That's correct.
On certain matters, even if they may not be in the concurrent.
Absolutely, yes.
So they were temporary with reference to time. They were temporal.
I agree.
Then 370 is an illustration of a case which is temporary in the sense it will operate till abrogated. Would it be? I mean, we're just, when Mr.
Not
Sibal,
till abrogated.
when we are putting your point, it's actually we are thinking
I
that.
understand.
Yeah. We are just.
I understand, Malaj. I mean, this is, your lordships have always done this, Malaj. Your lordships, this is a very fruitful debate because we all have to understand. Well, we are here standing
it's only in
for
that
India.
process that we
We're
can
standing for the
really,
people of India. We're not, Malaj. This is not something that we believe we are totally integrated into India. That's not an issue, Malaj. We have said so. Therefore, there is no, as far as, I mean, our constitution says we're an integral part of India. So where's the question of moving away from that? Yes, yes. Yes. Yeah. Yeah. Participated in the deliberations of the Assembly in India at a time when the bulk of the Indian Constitution had already been adopted. It was at this stage that the constitutional position of this state was determined in the Constitution of India. This is very important. It was in a collaborative exercise, a dialogue. item 43.
Yes.
The Lordships don't mind, it's PDF 44. The Kashmir Accord, now that's a political document. (1975) was entered into, my lords have it. PDF 44. The Kashmir Accord 75 was entered into between the Government of India and the Government of Jammu and Kashmir. Under Clause 1 of the Accord, the relationship of the state of Jammu and Kashmir with the Union was to continue to be governed by Article 370 of the Constitution. Now, kindly note, Malaj, the temporary provision was over. Still be governed.
Why was this required to say it is to be governed if it is a permanent feature?
Sorry?
Why was there a requirement 27 to say this will continue to govern when it was a permanent feature?
Malaj, it also reiterated the residuary powers of the state. Malaj, that's not the only thing that happened. It's just a reiteration of the position that was accepted by the Government of India throughout, which is the constitutional position. After all, it's a political accord, Malaj. I mean, it has no legal basis that way, but it tells you of the intent of the signatories, Malaj.
Political change at that time.
Yes, I know that. I know that. Malaj, in any case, 75 is a momentous time in the history of this country. Yes. Luckily, I was out of the country, Malaj, so I.
The response to Sheikh Abdullah's settlement.
Yes, yes, yes. So, fine. Huh? And jail for ultimately 14 years. The background is, Malaj, that whenever he came out, he was saying that, no, no, give us autonomy, give us autonomy. It is in that context that the accord was there, that you can't get out of 370. That's really the background to it. He was put in jail even by Mrs. Gandhi. So, Malaj, the rest of the list of dates. Kindly now see, come to straight to PDF 47. On 29th of March 2017. Then, of course, the clamoring began, remove 370, do away with 370. But that's a separate issue. I mean, we're not concerned with that. So
You are on 55 now?
55, exactly, man. Lord Justice Khanna has 55. Justice Gawai. That's Suryakant. Yes. Member of Parliament Ratna Denag raised a question whether the Minister of Law and Justice, as to whether the government proposes to amend and remove 370 related to Jammu and Kashmir in the near future. If so, details thereof, if not the reason, therefore, whether this will help in providing equitable justice to the people of the state, and if so, the details thereof. Minister of State and Law and Justice, so and so. At present, there is no such proposal under consideration.
These are only proposals.
These are only proposals, all no throughout. This goes on, Malik.
Yes.
Then 57 is Malad's section 92. This is important. Item 57. Section 92 of the Constitution of Jammu and Kashmir deals with provisions in case of a failure of the constitutional machinery in the state. Provision permitted the governor to, by proclamation, assume to himself all the powers and functions of the government of the state. Such a proclamation would, in terms of 92(5), require the concurrence of the President of India. Under 1923, would cease to operate 6 months after it was issued. On June 20, 2018, the governor, with the concurrence of the President, issued a proclamation under 92, declaring governor's rule in the state. This is important. Now we're coming to the present controversy. We can do it tomorrow, Madam.
We can then continue tomorrow.
Deeply obliged.
Oops.